have going on this morning is, once again, every day this is happening now. This cattle rancher, Charles D. Hall and Astrid Hall, have 140 acres. But where are they putting their cattle and their horses? Right on our fence line, on the easement and the property that they stole from us when they stole our gates and cut the locks off. They had no trespass signs that they took without any court order of ejectment, and knowing that the ownership had passed to us boundary by acquiescence. And there they are, there's our house. So when they come in up there, this whole massive pack of pooping, filthy, bacteria, virus shedding cattle. The odor, the bellow, the smell, and it looks like a construction zone here on this property. So if they were going to steal part of the property, why didn't the circuit court judge join them into Darlene Baylor's lawsuit about our property? Especially when Darlene Baylor swore under penalty of perjury that there was no boundary dispute. She did that, knowing and willfully swore under penalty of perjury. There was no boundary dispute in order to get us to sign her mortgage papers and everything else, and to induce the title insurer, Old Republic, to issue a title policy. Now, this is a boundary dispute. They've stolen land that we had boundary by acquiescence, which is evidenced at minimum by my Facebook post showing that I installed the gate and fencing down there where they removed it with the no trespass sign and cut the locks off. And that was installed by the Facebook post posted in the regular course of business at that time as it happened on July 21st, 2010. Now, the statutory statute of limitations expired on July 20th, 2017. That was after the other lawsuits that were out there. And the Hall's lawyer, Richard Fambiani of Chandler, Lang, Haswell, and Cole, I believe it is, blew the statute of limitations to bring an ejectment lawsuit. Instead, apparently, he instructed his clients, the Halls, to come in here with no court order with the sheriff and steal the land back from us, knowing that he had blown a statute of limitations. Why that's not a disbarrable offense that the Florida bar would go after this lawyer for, I don't know. But that's what he did. And when the statute of limitations, the 7-year statute of limitations expires with no ejectment lawsuit filed, it bars the right of entry of the person that's claiming that they want possession of that land. So the sheriff's lawyer, Cynthia Wygant, told me she doesn't need to know all the little details about this land, this dispute, or the lawsuits. She said that the sheriff does not resolve disputes over land. Well, but that's exactly what she did, because Miss Wygant is a lawyer. Now, even if she didn't understand boundary disputes, she was under a Florida bar rules duty regulating lawyers to consult a board-certified specialist in real estate. Now, I happen to know, because I pulled it up on the internet, that in order in Florida to pass a board-certified real estate exam, boundary dispute questions are examined on those exams. Now, Ms. Wygant, there's no indication she ever consulted a board-certified specialist. She just said it's okay for the sheriff's department to come in here under threat they would arrest my husband and I and allow Charles Hall to steal this land right here. So the Sheriff's Department, Ms. Wygant, did resolve a legal dispute because, and how did she know that? Because she had no court order saying that the Petranos are rejected off this piece of land. Now, Darlene Baylor wrote me an email to induce me to sign the mortgage papers that barbed wire fence way out there where those cows are, that was my boundary fence and I could replace it. So it's clear that there's an overlap either by boundary by agreement or by boundary by acquiescence that required the circuit court judge to join Mr. and Mrs. Hall as indispensable parties in the foreclosure case that was brought against us by Darlene Baylor when we complained, fix these problems. And she didn't want to. And her lawyers didn't want to. They just said, pay us for being land swindled by us. That's what they said. Now, this would not happen to me if I didn't have an autism spectrum disorder. The only reason that these lawyers and the sheriff did this and stole this land, and the judge did this, Judge Monica Brasington, who allowed the Halls to do this, she applied an incorrect legal standard. Do the deeds legal descriptions overlap? Well, that's not as a matter of law, that's not the legal standard that you apply in a boundary dispute. You apply the legal standard of a boundary by agreement or a boundary by acquiescence, and she did not do either. Because if you apply the legal standard for a boundary by agreement, it's clear that our deed and the Hall's deed and the land, because of where the boundary fence was out there, they do overlap. So we're being asked to pay for all that wood fencing out there that Mr. Hall has stolen, all that barbed wire fencing, everything, this land that Mr. Hall has stolen. We're being asked to pay for that. $160,000 and even more money on a judgment that Judge Brasington entered. Now, doesn't that smack of unfairness in the extreme? We did not get what we were told that Baylor sold us. Darlene Baylor, the land swindler from over by Bunnell, Florida, and her lawyers at the Chiamento Celis Dwyer law firm swindled us. Look at this ugly scar across our land, these cattle, these horses on our land over here, and we're being told to pay almost $200,000 for this. It only happened because of autism spectrum disability discrimination, period. If I didn't have an autism spectrum disorder, they never would have done this. And there's the sheriff and Hall's deputized camera filming our house, our barn. Now, is it a Fourth Amendment violation for the sheriff to assist the Halls to remove a locked perimeter gate with a no trespass sign when a boundary by acquiescence gave us ownership of that land? I'll leave it for everybody. Look at the damage, the injury, in fact, inflicted on us here.